Assalamualaikum warahmatullahi wabarakatuh to Dr. Soni. I hope you're having a good day. My name is Izzatunnadhirah binti Azizi 1912172, and today I will be presenting my case review which entitled Niro Ceramic Sales and Services Malaysia and Another and Lo Chin Guan and Others. It's a case of 2018 Malayan Law Journal Unreported 1868. So this case actually a case concerning restraint of trade. So the flow of my presentation will go like this. I'll start with the material facts of the case, followed by the extensive discussion of legal issues. And then I will provide the arguments from both plaintiff and defendant and the overall decision from the court. And then this presentation will be concluded with analysis and personal view from myself. So we'll start with the facts of this case. The plaintiff in this case are members of the Niro Ceramic groups of companies, while the defendants are former employees of the plaintiff. There are actually 4 defendants in this case: Defendant 1, Defendant 2, Defendant 3, and Defendant 4. However, Defendant 3 and Defendant 4 are actually the companies incorporated by Defendant 1. So the relevant defendants here are the defendant relevant in our discussion here are Defendant 1 and Defendant 2. So Defendant 1, during his working period with the plaintiff, was a general manager of domestic sales division from 23rd November 2009 to 27th November 2017, which approximately 8 years, while Defendant 2 was a sales manager and he worked there from 1st February 2002 to 31st January 2017, which around 15 years, more or less 15 years. So both defendants were alleged to cause the incorporation of Dongpeng Malaysia Sdn Bhd and one other company to sell, market and distribute tiles. And this was done without prior knowledge nor approval from the plaintiff. So how does the defendant do that? Is by misusing the confidential information and disclosing trade secrets owned by the plaintiff. So this incorporation has caused competition with the marketing, sales and distribution of Niro tiles, which are owned by the plaintiff. Therefore, in this case, the plaintiff applied for 2 things. The first one is an interim injunction to restrain defendants from doing various acts. And the second one is an order for the defendants to deliver up the plaintiff various documents purportedly containing confidential information and trade secrets obtained from the plaintiff, whether indirectly or directly. So there are 2 legal issues raised in this case, which is first, whether there is breach of confidentiality or trade secrets on behalf of the defendants, and second, whether the order sought by the plaintiff infringed Section 38 of Contract Act 1950. So now we'll be discussing the 2 relevant legal issues raised in this case, starting with the first issue, which is whether there is breach of confidentiality or trade secrets on behalf of the defendants. So in this case, the plaintiff alleged that Defendant 1 and Defendant 2 were in possession of confidential information and trade secrets belonging to the plaintiff, which they misused to the detriment of the plaintiff. In other words, according to the plaintiff, the act of misusing the confidential information and trade secrets had actually caused the plaintiff to suffer loss and damage. However, before we can determine whether the element of breach existed or not in this case, we first need to determine whether the information in the possession of D1 and D2, Defendant 1 and Defendant 2, was in fact confidential as purported by the plaintiff or not. So in deciding this, the court took note of the decision of Vision Care Sdn Bhd and Another and Dynacare Melaka Sdn Bhd and Others, where it was pronounced that if the impugned information was from within the general fund of the second defendant's own knowledge, exposure, and experience accumulated in the die-cast industry over the years, as was the case here, and this will include potential customers, price trends in the market or public domain, etc., there was definitely not grounds in our assessment to hold that there had been a breach of fiduciary duty or even a breach of confidentiality by the second defendant in this case. Here, I would like to stress about the statement of within the general fund of the second defendant's own knowledge, exposure, and experience. So from here, the court held that this kind of information is not tantamount to breach of confidentiality. On top of that, quoting the judge in the case of Ganesh Raja, anak lelaki Nagaya and others, and our rubber industry Sdn Berhad, the judge said that the customers, suppliers and forwarders list together with their contact numbers must be established to be information of confidential nature. Even access to the information in the company must have been limited only to certain persons. General information available to all employees or public could not per se attract the doctrine of confidentiality. So from this case, what we can understand is that the information that is readily available to public does not by itself attract the doctrine of confidentiality. Applying this to the current case of Niro Tiles, first and foremost, the plaintiff in this case failed to prove to the court's satisfaction that the documents allegedly being kept by Defendant 1 and Defendant 2 were classified as confidential information or amounted to trade secrets of the plaintiff. In addition, the plaintiff did not reveal the details or the particulars of the documents for the court to determine their true nature. It means that the court could not clarify whether the documents were indeed confidential or not as purported by the plaintiff. And not only that, most of the information can be found in the public domain and can be accessed online. So adopting the principle used in the previous case of Ganesh Raja, anak lelaki Nagaya that I've mentioned before, where it was stated that general information available to all employees or public could not per se attract the doctrine of confidentiality, we can say that in this case, the information is clearly not confidential as it is available online, and not only the employees but the public also can have access to the said documents. Actually, in order for one information to be protected by the law of confidential information, information must be confidential in nature and should not be available in the public domain. However, if there is actually a breach of confidentiality, the plaintiff can actually sought for springboard injunction. What is springboard injunction? It is an injunction designed to remove or limit the advantage or head start that an employee has gained through unlawful activities. For example, the misuse of confidential information. So historically, the springboard injunction was developed from cases relating to the misuse of confidential information. However, in the case of QBE Management Services UK Limited and Daimok and others, which is the leading authority on this matter, the High Court confirms that the grounds of springboard injunctions have been extended not only to the breach of confidentiality but also to the breach of contractual duties, fiduciary duties, and the duty of fidelity. Having said that, the plaintiff did not satisfy all the legal tests outlined in the case of QBE Management Services, since they failed to provide sufficient evidence to support their allegation. Therefore, the springboard injunction cannot be granted because the circumstances of the case did not justify for the injunction sought by the plaintiff. So for this matter, the court held that the information in possession of Defendant 1 and Defendant 2 were not confidential in the first place. There is not enough evidence, or there is insufficient evidence to prove that the defendants had actually used or utilized the information to cause harm to the plaintiff. Moving on to the second issue, which is whether orders sought by the plaintiff infringe Section 28 of Contracts Act 1950. Section 28 of Contracts Act 1950 provides that every agreement by which anyone restrained from exercising a lawful profession, trade, or business of any kind is to that extent void, except for the three exceptions, which is the agreement not to carry on business of which goodwill is sold, agreement between partners prior to dissolution, and also the agreement during continuance of the partnership. Simply speaking, the intention of this particular section is actually to promote free trade and free movement of labor. So, in the case of Millennium Medicare Services and Nagadevan Mahalingam, case of 2016, the court held that the negative governance between employer and employee contracts pertaining to the period post-termination and restricting an employee's right to restrict employment and or to do business in the same field as the employer will be in restraint of trade, and therefore a stipulation to this effect in the contract will be void. In other words, no employee can be confronted with this situation where he has to either work for the present employer or be forced to idleness. So what we can understand from this case is that an employer cannot restrict his employee from finding a job or doing a business in the same field as the employer, because those actions will be amounting to restraint of trade. So applying this to the current case, which is the case of Niro Tiles, among the prayers sought by the plaintiff is to restrain the defendants through their agents, employees, or servants from competing in business with the plaintiff. So in view of the terms of Section 28, the defendant should actually be free to run the operations of other companies upon the expiration of his employment contract with the plaintiff. So the plaintiff prayers here are actually an attempt to obtain what they are unable to obtain by contract, because such terms will be against Section 28 of Contract Act 1950. Had the terms been put in the contract, it will be against the particular section of Contract Act that will render any provision restraining trade or competition as void. In reality, the plaintiff actually sought the order as a sort of attempt to stifle or to hinder competition and unlawfully deny the defendants their livelihood based on knowledge and skills gained during their past working years with the plaintiff. So for this matter, the court held that the order sought by plaintiff appeared prima facie to be in reality in restraint of trade against the defendants, and it is in conflict with Section 28 of Contracts Act 1950. Therefore, the orders are not granted by the court. Now we'll discuss the arguments provided by both counsels. As for the part of the plaintiff actually did not argue much regarding this matter. They just alleged that the defendants have access to the documents purportedly containing confidential information or trade secrets belonging to the plaintiff. And they also argued that the defendants had used that information illegally that eventually caused them loss and damages. However, on behalf of the defendants, there are a few arguments that should be noted. Firstly, when the documents were handed to the plaintiff employees, there was no classification that the document contained confidential information or trade secrets. The plaintiff never asked two former managers who has the same access to the same documents to return back the document, when at the time the plaintiff actually knew that the two managers were going to join the companies belonging to the competitors of the plaintiff, and this fact was never denied by the plaintiff. The defendant also averred that the information is readily available in public domain and obtainable by subscribing to or purchasing from a trade information service provider, ISP. The public domain that I've mentioned before is actually BCI Asia, which is a leading provider of building and construction information across the Asia Pacific region. In this website or in this domain, we can actually obtain the information regarding construction company and so on. So the documents have also been retracted from the court's records and hidden by the plaintiff. So the court could not clarify whether the documents is actually confidential or not. Now, as a whole, the court actually held that the evidence relied upon by the plaintiff is insufficient to establish any of the pleaded causes of action on prima facie basis. The application is in its scope far too wide, excessive, and unreasonable to be considered and amounts to unfair protection of plaintiff business. So now we will move to the last part of this presentation, which is analysis and personal views. So with regards to the issue of breach of confidentiality and trade secret, in general, an ex-employee is disallowed to wrongfully use or disclose the confidential information belonging to his ex-employer. For example, memorizing a formula or a list of the employee's customer and taking away such list for personal use, because this action is improper and will constitute an act in bad faith. So an employer is allowed to set out in the contract covenants forbidding the employee from the use of any confidential information and trade secrets and disclosing or divulging them to others, and such covenants are not restraint of trade. Indeed, in the case of Schmidt Scientific Syndrome Berhad and Ong Han Swan, the court held that to restrain employees from using, disclosing, and or divulging confidential information and or trade secrets of their former employees to their detriment is not restraint of trade. This shows that the law vigilantly or clearly protects the employee's interest in such confidential information abuse by their ex-employees. However, with respect to the current discussed case, the first and foremost, the plaintiff could not even come with any proof to clarify that the information kept by the defendant were confidential as purported. The information, as I've stated before, is already available in the public domain, and people can easily access the information by Googling them and even subscribe to the domain. So how could the plaintiff allege that the information was confidential when it is just one click away from the public? Most importantly, there is not a small amount of evidence adduced by the plaintiff to show that the defendant had actually used or utilized the information after they were being terminated by the plaintiff. So in referring to the case of Repco Malaysia, Syndrome Berhad and Tan Tohpat, the material facts of this case are actually quite the same with the material facts of our current discussed case. In this case, the plaintiff sued the defendants, which happened to be the former employers of the plaintiff on the ground of breach of confidentiality. However, the court in this case dismissed the plaintiff claim as he failed to prove the requirements for claim of breach of confidentiality. As long as the defendants did not obtain the information or acquired the knowledge surreptitiously or secretively, it does not constitute to trade secret. So in the current case, we can see that the defendants will have acquired information and knowledge regarding the marketing and distribution of tiles through their years of being the general manager and sales manager during their working period with the plaintiff. Next, moving on to the issue of infringement of Section 28 of Contracts Act 1950. So Section 28 in general prohibits restraint of trade, in which it provides that every agreement by which everyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. So as a matter of fact, Section 38 is interpreted strictly by Izzatunnadhirah, where it will render all covenants in restraint of trade void, even if the covenants in question were reasonable. This is because the validity of such covenants is not subject to the reasonableness test as required under common law, but rather it depends on or contingent upon the three exceptions outlined in the particular section, which is Section 28. So the rationale behind Section 28 and the court's decision is that no one should be prevented from pursuing legitimate work or business. So an ex-employee is allowed to compete with his ex-employer by conversing or doing business with the latters or the employer former customers. So this is in line with the general principles of Section 28, allowing the competition and is consonant with Section 28 of Contract Act 1950. So employees with specialized skill and knowledge in niche areas will naturally only be able to work within a small industry. So preventing them from working with competitors will effectively limit their ability to make a living. So in the case of Polygram Records, Syndrome Berhad and the search, the court held that Section 38 is only applicable in cases where a person is restrained from carrying on his trade or profession in the traditional sense of the doctrine, that is, in the post-contract period and not during the currency of the contract. So, in this case, the order of the plaintiff, which is to restrain the defendants from competing in business with the plaintiff, was clearly infringing or violating Section 28. Why so? Because the order does not fall in any one of the exceptions of Section 28, which are agreement not to carry on business of which could be sole, agreement between partners prior to dissolution, and also agreement during continuance of partnership. So even if we want to apply the principle of reasonableness as deployed by the common law, it is certainly not reasonable for the plaintiff to do so because the defendant have resigned from the plaintiff company. To restrain the defendant from working after the termination of employment or resignation, be it with competitors or on their own, will effectively deprive them from their livelihood. Actually, this is just an additional information regarding the background of the plaintiff and the defendant. The plaintiff actually, the plaintiff in this case, Niro Ceramic Sales and Services Sdn Bhd, was actually a company founded in 1992 and involved in the business of wholesale distribution of stone, cement, lime, construction sand, gravel, and other construction materials. While one of the companies incorporated by the defendant, which is Dongfeng Malaysia Sdn Bhd, is also involved in a tile business. The company was under Dongfeng Holdings and has strong leading advantages in terms of ceramic products, including porcelain tiles, ceramic tiles, glazed porcelain tiles, curtain wall tiles, and others. Therefore, it was not surprising that the plaintiff sought the restraint of trade order by the court because they feared of the competition brought by the defendant will cause them loss in the future. So I think that's all from me. Thank you.